Now, the New Zealand police have 2 weeks to appeal a court decision accusing them of misleading the courts. A judge has stopped a court case involving 21 members of a Nelson gang after police faked the arrest and prosecution of an undercover officer who'd infiltrated the bike gang. The police refused to comment, but Police Association spokesman Greg O'Connor has defended the action.
Only way police anywhere in the world have been able to infiltrate serious criminals like these gangs is through creativity.
Well, this comes off the back of the .com case and the Uruwara 4 case, where police acted illegally during those investigations. Chris Gallavin is the Dean of Law at Canterbury University, and he joins us now. Chris, we just saw Greg O'Connor basically defending the intention of the police in this situation.
Well, I think many members of the public could understand the intention of the police, and Greg has to really defend the police. That's his job, and I think there's many layers with the judgment here. And one of the really aggravating features of this case was that the police failed to keep the Chief District Court judge, then the late Russell Johnson, completely and utterly informed of exactly what was going on.
In fact, they almost, looking at the judgment, they almost misled him into believing that this wasn't setting a precedent.
Yeah, Justice France didn't quite go that far, but he did say that he thought it seemed inappropriate, that he almost gave the impression of an informal chat with the judge in chambers where they had a letter that he didn't really want to see, and that it's not so much that the police can't do anything like this, you know, as far as the ingenuity that Greg O'Connor is talking about. The police may be able to do that to ingratiate their undercover detectives in stings and raids like this, but to keep the courts completely up to date with what they're doing is the key point here.
Yeah, because the police have defended themselves, saying, look, we did this to protect our undercover officer, or rather to protect the operation from going belly up. We were that close as such. But you would argue, as has the judge, that they've completely crossed the line here.
Well, there's a subtle point there. It wasn't necessarily to protect the officer, it was to protect the operation and to ingratiate them into the gang. And I think there's sort of subtle differences here. I don't think this is actually just a cut and dry black and white situation, and the judge does have a discretion in balancing the circumstances. And one of the considerations that may have been that wasn't a factor here was whether it was necessary, whether there was an emergency, whether there needed to be somebody to be protected in the circumstances. So it's not just a case of, you know, this has occurred and automatically it results without any discretion in the hands of the judge that the case gets thrown out. There is quite a nuanced test that needs to be applied. Yeah,
and I saw that the judge had actually made that distinction, hadn't he, that this undercover officer could have been pulled at any stage. He wasn't at risk per se, but it was the operation. Now, do you think the police, though, should face charges? You know, they've effectively acted fraudulently here.
Well, I think the judge, Justice France, has been pretty generous with the police. He said that there was no lack of bad faith, but it's hard to think of any circumstances that would get any closer to there being a lack of bad faith. And I think it's ridiculous that the police would have even thought that that they would be able to do this, let alone keep the courts in the dark. And you know, the police have got a huge amount of responsibility, and as we, as members of the public, want them to be able to exercise that with due care and attention, and not in a way that's you know, not subject to any oversight. They don't have an unlimited discretion. They have great power and they have great responsibility. So yeah, it's getting pretty close to there being bad faith, and that especially in the circumstance with the search warrant, which is completely utterly just trumped up, and the forging, or at least the purporting to be a deputy registrar, and the signature on the bottom of the warrant, and then going out and executing it. Okay, not searching a private person's property, but actually forcing through compulsion on the back of the warrant somebody to come and open up a yard and a storage unit is. You know, this is stuff we don't want our police officers doing on a regular basis.
Well, let's widen this, because it does seem to be happening on a more regular basis, talking about the .com case and the Uruwara raids. Now this, is there a disregard for process? Is it becoming more commonplace? Or are police just under more scrutiny, do you think?
I think the police are probably under more scrutiny. I have some sympathy with them, but You know, we live in a society where the police have a very important role to play, and they, most people are very appreciative of the role that they play in the execution of their duty, and 99.9% of the time that we have no problem with that. But in these sort of high-profile cases where the public are demanding answers, they're demanding accountability, both as far as the apprehension of criminal offending is concerned, they are under a huge amount of pressure, but they can't forget that they have a responsibility that goes wider than merely just putting who they think are guilty criminals before a court, that they have a responsibility to you and I as members of society and the public as well.
Which, Chris, possibly sort of is looking back a wee bit to policing of old. So do you think culturally there's an issue here with the police, or is this just a misguided intention again?
No, look, I think that there have been a few examples over the last few years where you might be able to say, hey, look, is this a trend, a pattern? But I don't think this is a symbolic of a systematic change in the culture or behaviour of the police. And look, they're getting a rap over the knuckles every time they do this. And the courts have the authority, both under the Evidence Act and an inherent jurisdiction, as was the case with Justice France exercising a jurisdiction yesterday, to, well, effectively discipline the police and say, hey, look, you've stepped over the mark. You know, and then, like I said, they're not unlimited. You know, we might be tempted to torture people to get confessions, which might actually result in conviction rates going up, and we could actually get a lot of quite reliable information through torture. There'll be a lot of unreliable evidence as well, but we've got mechanisms in which we can actually deal with the issues of reliability. Why don't we do it? Because we don't live in a society where police have that, you know, unfettered discretion to do what they think just because the ends justify the means. They don't.
Yep, but we do want to see the bad guys locked up. It has to be done properly. A bit like anyway, Chris. Look, thanks for your time. Very quickly, do you think these 21? There's a stay of proceedings in these charges against the 21. Do you think they have a very good case now just to walk away from this, to get off scot-free, or do you think those charges will still be faced in court or tested in court?
No. Well, the stay just puts an end to it, and you know they're probably feeling pretty lucky at the moment. Members of the public might think, oh, 21 gang members, drugs, and what have you. What's going to? You know, the courts are going to the hell in the handbasket, as the Sensible Sentencing Trust would probably jump on the bandwagon and say that. But I think there's some wider issues, some really important core public policy issues here, and the police just have to just watch what they do.
All right, Chris Gallavin, the Dean of Law at Canterbury University. Thank you very much for your time this morning.